We welcome our audience to another EPW editorial conversations. This time, the editorial is titled The Benefit of the Doubt Should Go to the Voter. This editorial of ours is published in volume number 61, issue 22, the 30th May issue. Let's get into the matter, sir. We're with our editor, K Arun. Let's start with the problem at hand, sir. What is the special intensive revision and why is there now a need for it to be introduced in Bihar? And before that, in terms of a precursor to Bihar, what concerns has its implementations raised in states like West Bengal and Assam?
See, there is nothing wrong in principle with an intensive revision of the electoral roll. Periodically, it has to be done. People who are on the voters list, the electoral roll, they move away to a different place. Increasingly, India is a migrant nation. Some of them die, and some of them might no longer be in the country at all. So, electoral needs to be thoroughly updated once in a while, and this is the purpose of the special intensive revision. However, the special intensive revisions you have been witnessing of late, starting with Bihar, have been special hurried revisions without giving sufficient time for the actual procedure established by the Election Commission itself to be undertaken thoroughly. And this is resulting in large misgivings about voters not being included, voters who have been excluded not being given a chance properly to make their case at why they should be included, and the adjudication of these claims not being completed. This is most unfortunate. This is why people went to court to challenge this procedure, but finally the Supreme Court has thought fit to give its imprimatur this exercise. It has approved the exercise in totality.
Coming to the Supreme Court judgment, why does this raise concerns about the expectations of the judicial protection of electoral rights in democracy?
The Supreme Court has given its entire blessings to the way SIR has been undertaken in Bihar. Presumably, it will give the same approval to SIR in other states as well when these come up before the court. Now, the question is, the court has said the limited authority that the Election Commission has in determining whether a would-be voter is a citizen or not is entirely justified. This, to my mind, is a grave mistake. Now, the Election Commission is not the competent authority to determine whether someone is a citizen or not. This, even the election, so not only the Election Commission, the Supreme Court concedes. The Supreme Court agrees that an agency or the Ministry of Home Affairs is the right agency to decide whether a person is a citizen or not. However, it says, since the Election Commission is charged with preventing non-citizens from voting, indirectly it has the mandate to determine whether somebody is a citizen or not. This, to my mind, is a wrong reading of the 10 requirements. The Election Commission's job is to ensure that every citizen gets the constitutional right of franchise, to be able to take part in the democratic process and choose who will represent the citizen in legislative bodies at the state level and the central level. Now, that is the case, and plus, it has also the responsibility under the Act to deny such voting rights to non-citizens. These two together combined, to my mind, would say the following. If somebody places evidence before the commission that so-and-so, Mr. X or Mrs. X, is not a citizen, and that proof is valid, then the Election Commission should actually remove that name of the person X from the voters list. Therefore, it is complying with the requirement not to disallow non-citizens vote. However, it is not his job to decide who is a citizen and who is not a citizen. It is an extremely important task beyond the remit of the Election Commission. And therefore, for the court to say that the Commission could, for the limited purpose of determining the right to franchise, can go into citizenship is making a mistake. We have seen that happen later. The newly minted Chief Minister of West Bengal, Mr. Suvendu Adhikari, has said that 30 lakh women will no longer be entitled to some transfer payment benefits under a government scheme because they have been removed from the electoral list under SIR. Now, this at a time when 27 lakh people whose names have been removed under SIR are still awaiting adjudication, or they claim that they actually are entitled to vote. So the election took place before these adjudications could be completed. So 27 lakh people potentially could have been citizens, might not have been citizens. In actual case, the benefit of the doubt should actually go to the would-be voter, isn't it?
So, delving a step further into how this is being rolled out on ground, why has it become an individual's responsibility to prove their citizenship in India?
Exactly. So the principle of natural justice is that you are deemed innocent until proved guilty. If your guilt is established, then of course you are guilty. Till then, you should be presumed to be innocent. So if somebody says you are a non-citizen, then it has to be proved. If it is not established that that person or he or she is a non-citizen, the person should be deemed to be a citizen. The benefit of the doubt should actually go to the would-be voter rather than to anybody who's accusing that person of being a non-citizen. It's as simple as that. This principle of natural justice is violated when the election commission unilaterally decides on the basis of whatever evidence it has that the person is not a citizen. The Supreme Court then gave its approval to the procedure followed by the election commission. Then it gave its sanction to the documents required to furnish proof that somebody is a citizen. Now, this is the most dubious part of this. In this country, our governance is so lax that citizens do not really come into contact with the state machinery to generate a record very often. So, a passport, for example, is considered a valid document of citizenship. Only 10% of Indians actually have a passport. And even these limited number of passports are cornered by a few states like Maharashtra, Kerala, etc. Majority of the passports, Punjab and Haryana, all these states, Gujarat. So in eastern India, most people lack any passport. And ultimately, if you think properly, even a passport depends on what? A police constable is sent to verify the address of the person, right? And police verification, we often know how thorough that it is. Even if somebody is a genuine citizen and everybody around knows it, unless a policeman is satisfied that that person is a citizen, he will not give that certificate. And that depends on certain considerations which we don't want to go into in this podcast. Now, what is the guarantee that somebody who is not actually a citizen can meet those considerations and influence the police constable to certify the person is a genuine citizen? Another thing that is accepted as proof of citizenship is the birth certificate. Now, in India, it's only after 1989 that birth certificates became fairly common in many parts of the country. But even now, we know that the government runs many schemes to ensure what is called institutional delivery. That women give birth in a hospital or an institution where then automatically a record will be generated of the birth. That is still in a fairly incomplete form in this country. So many births might not be recorded even today. And what about people who were born earlier? Now, a birth certificate by itself actually is not proof of citizenship, because as per the latest law, the amended form of the Citizenship Act, after the 2003 amendment, you also need to establish that both your parents were citizens, because the 2003 amendment says neither parent must be a non-citizen. One parent must be an Indian citizen and the other parent must not be an illegal immigrant. Now, how do you establish that? Then you will need the birth certificates of the parents.
in order for a valid birth certificate of somebody who was born in India after 1989 or after 2003 to be valid, then that person's parents must also be able to produce a birth certificate. How is this possible in this country? Large numbers of people in the Indo-Gangetic plains experience devastating floods, which, sort of wash away all their belongings, including whatever documents they might have. So the poor people very often struggle to establish their identity, establish their address, their proof of where they were born, whatever. Now, thanks to Aadhaar, now at least a resident of India can prove his or her identity. But that's only proof of being a resident, not of citizenship. How even a designated body of the Home Ministry will be able to establish citizenship is a matter of debate. It won't be an easy task. The most sensible thing would be to concede that if somebody wants to say that that person is a citizen, would be to concede that citizenship. Because unless there is actual active proof that the person is lying and the person has come from somewhere else. This being the case, for the Supreme Court to actually say that it is valid for the Election Commission to determine citizenship is completely a mistake.
This brings us to the final question, which is the big question. How should a democracy balance concerns about the integrity of electoral rolls with the risk that a large-scale verification exercise like this may inadvertently disenfranchise legitimate citizens, particularly the poor, migrants, women, elderly?
Yeah. So a special intensive revision should never become a special hurried revision. Sufficient time should be given in the first place. Secondly, a body that is capable of determining citizenship should be the one to designate somebody as a citizen or not a citizen. And that's not the job of the Election Commission. The Election Commission does not have a permanent staff. It relies on people who are giving voluntary time, or rather, they are summoned from schools or other lower division clerks or other office staff to do their job. They are not trained properly. They are not paid properly. Their incentives are properly often wrong. Some of them are so pressured they commit suicide. This is not a way to decide whether somebody is a citizen or not. There should be a special team, and they should have clarity on what is the proof required, and they should be given sufficient time to test the proof supplied. And in the absence of any very serious proof of what illegality, any document that is submitted, any claim made by would be a person whose citizenship is in question should be admitted in his favor. You know what I'm saying? The benefit of doubt should actually go to the would-be voter, to the would-be the person who claims citizenship, because there is actually very little way to decide citizenship: by naturalization, by descent, by place of birth, by seeking to register as a citizen. These were the considerations originally in the Constitution and in the 1955 Citizenship Act, which sort of codified these provisions of the Constitution. Then gradually brought in various elements of our fears about illegal migrants coming into the country and claiming of benefits and citizenship. Now, with the same Indian, when he goes to the US, would find similar conditions imposed on his citizenship claim, his aspiration to join that country, find these conditions extremely terrible, onerous, punitive, discriminatory, and unjust. But when these conditions are applied back home, then many people don't find anything wrong with it. So these kind of double standards should go. Ultimately, we are all part of humanity, and yes, being part of a country has its benefits, and our entire human being and whatever values we have, capability we have, our humanity should not be segmented by, as our Rabindranath Tagore put it, by narrow domestic walls. At the same time, the only way we can actually determine citizenship is by giving the benefit of the doubt to the person who claims citizenship. I think that is how we should go about this.
Thank you, sir. On that note, I think we can bring an end to this session. Thank you
Yeah.
for such a critical reflection on a matter that concerns a very pressing matter of our country. Our readers can please access this editorial on our website, epw.in, and please subscribe to EPW for more such content. Thank you.